Hello everybody and welcome back to the Law of Contracts. In this lesson we're going to talk about the next major circumstance in which we can bring a contract to an end, and this is by reference to the doctrine of mistake. Now, in previous lessons, we spent quite a lot of time examining the nature and the extent to which misrepresentation could be representative of a vitiating factor within contract law. We noted that there are various different kinds of misrepresentation, ranging from the idea of innocent misrepresentation on the one hand, all the way to fraudulent misrepresentation on the other. This lesson is, like I said, going to speak about the doctrine of mistake within the law of contracts, another major doctrine, another major element of doctrine that we need to explore in more detail. So, the doctrine of mistake does exactly what it says. It provides a stipulation that where a contract is essentially done on the basis of a mistake, that contract can be made void, or at least voidable, by the parties to the contract. We can divide the doctrine of mistake into three major types of mistake that it can exist in contract law. The first is this idea of common mistake. Okay, this is the first type of mistake that can exist. The second is mutual mistake. And then the third is unilateral mistake. And you can probably come to a conclusion as to what these things mean just by looking at how they are written and what they are called, but we will get to this in more detail throughout this lesson. So, common mistake exists where there will be an agreement, but both parties are mistaken in relation to the fundamental part of the contract itself. This is often in relation to some fundamental part of the subject matter of the contract itself. So, they are mistaken as to what the fundamental condition of a contract may be. Remember that there are various different ways in which we can delineate terms of a contract, and we've done this already. And we noted that conditions of a contract strike to the heart of the contractual arrangement, such that if a condition is to be misrepresented or to be mistaken, then you are mistaken as to what even the very nature of the existence of the agreement even is. An example of this taking place can be seen in the 1856 case of Courtier and Hasty. In this case, the first kind of common mistake is illustrated in this particular case, where there is a mistake as to the existence of the subject matter of the contract itself. This is known as res extinctia. Essentially, it involved the sale of Indian corn, which was in transit as cargo. During the transport of this cargo, however, the corn itself became unfit for sale and use, and so as a result of this, midway through the journey, the captain decided and made the decision to sell the cargo off to a third party. All while this was happening, while the sale was going off in a different period, in a different area, okay, the parties were contracted for the sale of the cargo under the assumption that it still existed, that it was still under the control of the captain of the ship. While some may believe foul play on the part of the captain, it was actually common and customary practice for a captain to go about selling cargo in this fashion if it was deemed to have been unfit for further transport. So it was actually quite a common feature, basically, essentially saying that if rather than having the cargo be unfit and arrive at its destination unfit and unable to be actually utilized, sell it as quickly as possible. If it's deemed to be unfit later on in the journey, in the voyage, then sell it now, essentially. But then when it comes to the contractual ideas relating to mistake, it argues here that when the claimant made the argument that the defendant should pay for the corn owing to the fact that they had taken on the liability in its transport, the courts held that the contract itself was rendered void. And it was rendered void, of course, because the contract did not exist, owing to the fact that the subject matter did not exist. If the subject matter of the contract did not exist, then the contract itself would not exist. If I contracted with my friend to purchase an alien spaceship, okay, I couldn't then sue that individual if I don't get my alien spaceship. I've made a contract on the basis of a subject matter that did not exist. There does not exist an alien spaceship, at least if you don't believe the conspiracy theorists, at least. And so as a result of that, there's no subject matter. This is known as a res extinctia. In this instance, we have here that, like I said, there's a contract of a sale of corn, but that went off and disappeared. Okay. A similar thing can take place if you've got the transport of property that's going in cargo. You make a contract for the purchase of that cargo, but at some point along the journey, prior to your making of this contract, the cargo falls overboard, or it gets destroyed in a fire, or something like that. But you don't know that it has happened, so you're basically contracting for the sale of an object that no longer exists or is no longer available to you. As such, as a result of which you have the idea of common mistake. In the case of Cooper and Phibbs from 1867, we can illustrate the second type of common mistake that can exist. This time we're not talking about the very existence of the subject matter in terms of common mistake, but rather we're talking about common mistake between the parties as to who the true owner of the subject matter is. This is known as a res sua common mistake. So, in this case specifically, there was a mistake relating to the renting of a fishery. The claimant had rented the fishery believing that it was owned by his cousins. In reality, this wasn't true. It was actually the owner of the property. He was actually the owner of the property, should I say. So he was renting it believing he didn't own the thing that he owned. He was renting his own property, essentially. And then, as such, he sought to get a contract rendered void on the basis that there was a common mistake here. We're not talking about a mistake as to whether or not the subject matter existed, but the true owner of the subject matter. He was already the owner of the subject matter, so there was a mistake as to who owned the subject matter in the contract, so it should be rendered void. And in reality, this is what happened. It got rendered void on the basis that there was this common mistake. Because you can't, of course, make a contract on the basis of there being a failure to know the true owner of a subject matter. If this happens and you are wrong about the true owner of the subject matter, then you can render a contract void on the basis of common mistake. Welcome back, everybody, to the law of contracts. In this lesson, what we're going to do is carry on talking about the processes that can lead to a contract being brought to an end. In the previous lesson, we talked about the concept of mistake. And in this lesson, what we're going to do is talk about the concept of mistake as to quality, or mistake of quality specifically. So this is the final type of common mistake that we can actually think about when looking at the concept of mistake within the law of contracts. In the last lesson, we talked about mistake as to the existence of the subject matter, as well as mistake as to the true owner of the subject matter. And we illustrated this with two pieces of case law, one being the idea of the creation of a contract for cargo which did not exist, since it had been sold by the person who had what was tasked with essentially transporting said cargo. We also talked about the concept of mistake as to subject matter, which was, of course, a contract which was created for the purpose of purchasing some particular property, some particular thing, but then it turned out later that that person actually already owned that particular piece of property, and so as a result of which there was mistake as to the true owner of the subject matter. This is the final type of mistake, and this is a concept of mistake which relates to the quality of the subject matter. Now, mistake of quality is and has historically not been considered a common mistake of such fundamental character, which would then, as a result of which, render a contract to be void. That's not historically how common mistake has essentially been operated. There are two main cases which illustrates this point quite clearly. The first is the case from 1932. This is the case of Bell versus Lever Brothers. In this case specifically, there was a defendant, of course, who had been one of the directors of a company. Now, before the expiry of this agreement, it was amended that the defendant leave early with the payment of £30,000 in compensation. The total compensation, in fact, was £30,000 and £20,000 to two different defendants. Some textbooks mistake this for £50,000 for one defendant. In fact, the textbook that, or at least a couple of the textbooks that I looked at, made this mistake. In reality, it was a compensation of £30,000 and £20,000 to two different defendants rather than £50,000 to one. Okay, simple as that. It later then transpired that the defendant had acted in a way which conflicted with the best interests of the company. They had violated one of the director's duties. Now, for those of you who would like to know more about the concept of director's duties, go over to our lessons on company law, where we have examined that in more detail. As a result of this, they did not require compensation in order for their contract to be terminated. So they terminated the contract with compensation, but then it later transpired that they had violated one of their director's duties, which meant that they did not actually need to give the compensation in order for the contract to get terminated. And then, as such, one of the things that happened was the company sought to recover that money on the basis that they were in fact mistaken in its payment. Of course, because they were mistaken as to the failure or the violation of the director's duty. The House of Lords, in fact, would reject this argument. And the reason why they rejected this argument was because they suggested that mistake was not, quote, of such a fundamental character as to constitute an underlying assumption without which the parties would not have made the contract they in fact had made. So, when we think about the mistake of quality as one of the common and mutual, or at least the common ideas of mistake, it is noted here that mistake of quality is not fundamental so as to constitute an underlying assumption without which the parties would not have made the contract in question. This is obviously unlike those other types of mistake where you would not have made a contract if you had known, for example, that the subject matter did not exist or that you had already owned the subject matter. Those are instances of mistake as to the existence of the object and a mistake as to the owner of the object, and both of those involve a circumstance in which you would come to the conclusion that they would not have made the contract had they known of that mistake. Another case to illustrate this point comes from 1950, and this is the case of Leaf versus International Galleries. This was a case in which a gallery, as you can probably imagine, had sold a painting under the assumption that the painting itself was a valuable piece. It was a valuable piece by Constable, apparently, according to the gallery's assumption. This, in fact, was a mistake. And it was in fact a mistake which was made by both the gallery as well as the purchaser. In fact, the painting was not a valuable piece by Constable. It was something else. And the problem here is, though, that the gallery had sold the painting under the assumption from both the gallery and the purchaser, they had sold the painting under the assumption that it was a very valuable piece of art, of classical art, which then meant that the painting was sold for a substantial amount of money. In fact, it was sold for far, far more money than it in fact was worth. And so when it came out and it was discovered that the painting in fact was not a Constable and in fact was worth a far less amount of money than in fact it was sold for, the parties sought to have the contract voided on the basis of the fact that there was this common mistake, a mistake as to the quality of the product. Again, the courts rejected this view, and they argued that the contract itself was in fact valid. And what this does is speak to the argument presented by the courts that the concept of mistake as to quality is not so fundamental as to ultimately render a contract void on the basis of such common mistakes. So it is not so strong as the other kinds of mistakes, as I've illustrated a second ago, when we looked at the concept of mistake as to the existence of subject matter or the true owner of the subject matter. Finally then, let's talk about the case of Great Peace Shipping Limited versus Tavlaris. which is a word that I can't pronounce, as you know. This is a case from 2002, and it was a case in which it was held that common mistake is only valid, and it can only void a contract where there is an impossibility in relation to the performance of the contract, in addition to other fundamental factors regarding subject matter. This is quite interesting because what this case specifically involved was a contract which had been made in relation to various different salvage services. Now, salvage is something that relates to maritime law, which we are not doing here. I'm sure we will do maritime law in the future, maybe one day. But fundamentally, what happened here is that the defendant had chartered a ship. The ship was the Great Peace. Falsely delivering the ship was only... falsely believing the ship was only 35 miles away from the salvage. In reality, the ship was in fact 410 miles away from the salvage, and as a result of that, the defendant cancelled their charter and contracted with another ship, which in fact was closer, and so could actually perform the salvage in a more reasonable time period. Part of the charter included a cancellation fee, and the defendant would have to pay compensation if they cancelled the charter. Makes sense. The defendant argued that there had in fact been a doctrine of common mistake applied, and so that the contract was void at common law. So there would not be the necessity to pay this cancellation fee because the contract was void. It never existed in the first place, fundamentally, at common law. And they sought to make this claim on the doctrine of common mistake because the ship was 410 miles away when he mistakenly believed it was in fact only 35. It was held, however, that there was no common mistake. And the reason for this is because when you talk about the concept of common mistake, it can only void a contract where there is an impossibility in relation to the performance of the contract itself. It was not impossible for the Great Peace to perform salvage services. They were 410 miles away, so the nature of the time period and the time frame in which this operation would have taken place was vastly different to what the claimant had, or the defendant, should I say, believed it was. But in reality, the ship was not, it wasn't impossible for the ship to perform the services that they were contracted for. So you're mistaken as to the nature of the agreement or to the location of the ship where it is, but you're not, the common mistake here doesn't render the contract impossible to perform. It only renders it a bit more difficult to perform, or not being able to perform in a certain time period. There was no specification in the contract as to how long it would take and how long it should take for the ship to go about its salvage services. So it wasn't impossible to perform the services that it in fact was chartered to perform. And so as a result of which the contract in question was in fact valid, and so because the defendant cancelled the charter, there was a cancellation fee that the defendant would have to pay. In this lesson, we're going to talk about the concept of mutual mistake in relation to contract law. So we're moving on to what is known as the second type of mistake. The previous type of mistake is, of course, common mistake. And we noted that common mistake can exist in various different forms, noting, for example, that mistake as to quality is representative of quite a weak form of of common mistake, should I say. But then you also have mistake as to the existence of subject matter, as well as mistake as to the true owner of the subject matter, both of which are far stronger concepts of common mistake. Mutual mistake is a different type of principle that exists within contract law. We'll explain in this lesson what mutual mistake is, as well as how it operates at the common law with some case studies and some case examples. So, mutual mistake is very similar to that of common mistake. Both parties have made a mistake as to the terms of the contract or potentially its subject matter. So that's another point that we need to make. The key difference here is, though, that with mutual mistake, when it comes to mutual mistake, unlike that of common mistake, the parties have made different mistakes, okay? So previously, when we looked at common mistake, they both had made the same mistake. So the example of making a contract about a subject matter that didn't exist. They're both making a contract on the basis of a subject matter, and they're both mistaken as to the existence of that subject matter. That is what we mean by common mistake. But in cases of mutual mistakes, there are two different mistakes, at least two different mistakes. And when we see that, we say that the parties are at, quote, cross purposes. And so when they're at cross purposes, we get mutual mistake. Let's illustrate this with some case law, okay? So the 1864 case of Raffles and Rittelhouse, which is another word that I am unable to pronounce, is a case which involved the delivery of cotton on a ship. The ship itself was called the Peerless, and the contract said that it would be delivered on this ship and it will be arriving out of Bombay, but it did not specify the month that it was going to arrive. Especially in the 1800s, the mid-1800s, it was probably unlikely to actually have a good understanding of when the ship was going to arrive, given that the journeys of that nature in that time period took probably a very long time, an inordinate amount of time. Unfortunately, for the people who contracted in this particular agreement, there were in fact two different ships with the same name that were both arriving out of Bombay, and one was arriving in the month of October, the other was arriving in the month of December. So unfortunately, there were two Peerlesses that were arriving out of Bombay, and one was arriving in the month of October, one arrived in the month of December. So two ships, same name, same place, roughly the same time. Okay, when it comes to shipping and all this kind of thing, the difference of 2 or 3 months is not really that huge, especially in the 1860s, as I've mentioned. So quite ironic and quite difficult to understand. Both the claimant and the defendant had different views about which ship the contract was in fact referring to. The claimant believed that it was a contract for cotton that was arriving in December. The defendants believed it was for cotton that was arriving in October. Oh yeah, I forgot to add as well that both the same ship of two different ships of the same name that were both arriving out of the same place in roughly the same time period and carrying the same cargo. So there was also that problem. It would have been easily solved if one was carrying something other than cotton, because then you come to the conclusion, it's the one that's carrying cotton that is the ship that we're referring to, because our contract is for the delivery of cotton on a ship. Unfortunately, they were both delivering cotton, so unfortunate there. So litigation was brought on the basis of a breach of contract, because there was a disagreement as to which ship, in fact, belonged to the agreement, which ship actually was the one that the contract was referring to. The courts were tasked with the job of identifying the operationalization of mutual mistake, and they concluded that if, on reading a contract, a neutral third party would be able to find a common intention as to which ship the contract was referring to, this would render that contract valid and binding. So if you take a neutral third party and you get them to read the contract, and you can see, and they can come to a conclusion as to what the contract is referring to, then this common intention would therefore render that contract binding, and whoever was wrong in that instance, in fact, would have to pay damages out of by way of breach, because they have breached that contractual arrangement. However, when reading these contractual terms, there was in fact no indication whatsoever as to which ship was being referred to, okay? Because they were both the same name, they both arriving out of Bombay, and it wasn't specified necessarily which month it was going to arrive. So the only distinguishing feature of these two ships, essentially, for our purposes, was which month they were going to arrive at, because there was the same name, they were going from the same place, and they had the same cargo. So the only difference between these two ships was that one arrived in October and one arrived in December. But because the contract doesn't specify which it doesn't specify the month that it was going to arrive, it doesn't specify that, then the only distinguishing feature is not part of the contract. So there is no distinguishing feature in the contract. There is no indication as to which ship the contract was referring to, and so there was therefore a mutual mistake, and the doctrine of mutual mistake was therefore valid, and the contract was therefore void. Another case is the case of Scriven Brothers and Co. versus Hindley and Co. from 1913. This principle that was established in the previous case relating to the ship was upheld in this case. The defendants in this case had made bids at an auction. It was for two different lots with the belief that they were bidding for hemp in both cases. However, it later transpired that one was hemp and the other was tow. As such, one was significantly more valuable than the other. Again, the court would have to consider whether or not a reasonable neutral third party would be able to make a determination in the contract as to whether or not they had brought hemp or tow, whether or not a distinction could be made here that is able to essentially delineate which lot was which. They considered that in both lots they both contained the same label, SL, which was a mark the purchasers believed indicated the presence of hemp. The courts concluded that a third party, therefore, would be unable to determine the difference between these two different lots and these two specifically within the contract, and so, just like in the previous case, the contract was void on the basis of mutual mistake. In this lesson, we're going to spend some time talking about the final type of mistake which can exist that can bring a contract to an end. This is, of course, the concept of unilateral mistake. And given the context of the previous types of mistake we've looked at, and given the name of this type of mistake, you should probably come to the conclusion that you know what this type of mistake essentially entails. This is the final lesson on the subject of mistake. We'll talk about, like I said, the final kind of mistake, this idea of mistake being unilateral in nature. Now, unilateral mistake pertains to those situations where, rather than both parties being mistaken to something, only one party is mistaken. Remember, common mistake was where both parties had a common mistake, i.e. they were both mistaken about the same thing. Mutual mistake is those circumstances where both parties are mistaken, but they are mistaken about different things. And then unilateral mistake, finally, relates to those situations where only one party is mistaken. In addition, the other party is aware of the mistake. And so a unilateral mistake will often take place in circumstances that relate to a contract where the contracting parties' identity or the specific terms or the nature, finally the nature of the signed document is mistaken. So that there are mistakes in those kinds of circumstances. And I would like to draw your attention first to the 1878 case of Cundy and Lindsay. This was a case in which a fraudulent third party had written a letter pretending to be part of a firm and send a purchase order for handkerchiefs from the claimant. The third party was called Alfred Blencarn, and the firm he impersonated was Blenchiron Incorporated. The invoice was sent by the claimant for the order, and it addressed to the corporation, not the third party. The property was then sold on to a further defendant, and at which point we see a litigation taking place where the claimant sues the defendant on the basis of the tort of conversion. Now, because the identity of one of the parties was mistakenly thought to be Blenchiron Corporation, the courts determined that the contract was void on the basis of mutual mistake. As such, the claim for the tort of conversion by the claimant against the defendant was in fact successful. Another case that illustrates the idea of unilateral mistake more specifically is the case of Hartog versus Collin and Shields from 1913. This illustrates the idea of unilateral mistake as it relates specifically to the terms of a contract. So this was relating to a mistake on one side relating to an offer which was to be put into writing. The defendants had been hide merchants who were in discussion about the specific sale of some items to that of the claimant. The discussion had amounted to the selling of hare skins. Specifically, it was 30,000 hare skins at 10 pence per skin, so quite a lot of hare skins, in fact. When the discussions had been more formally finalised, the terms were written differently. The terms were written as such: 30,000 hareskins at 10 pence per pound. Okay, so rather than it being per skin, it was then now per pound. So it was measured in weight, not in quantity. The shift in metric from 10 pence per skin to 10 pence per pound resulted in a significantly reduced final sum for the 30,000 hair skins. Given the fact that it was not relating to each individual hair skin, it was relating to the weight of the weight of the collective of the hair skins. In fact, it was a significant reduction given the weight of hair skins on average. The claimant wanted to maintain this lower price, as you can probably imagine, and so as a result of which sought to bring a claim to ensure that the terms that were written down had been adhered to. So the terms, essentially the dispute that existed here was in relation to the terms which were made vocally or made orally before the terms were put into writing, which was 30,000 per skim, 10 pence per skim. But then the dispute then arises when it comes to the claimant's argument that it should be the thing that is written down that is essentially adhered to, which is obviously 10 pence per pound. You can obviously understand why the claimant would want this to be advocated for, given the fact that they would be able to get 30,000 hareskins at a significantly reduced price than what was originally agreed before it was put into writing and formalised. The court held that it would have been clear the error on the part of the defendants by there would have been a clear error on the part of the defendants by the claimants, and so as a result of this, given that there was a unilateral mistake as to the term, and that this was known to the other party, and that nothing was said about this mistake, the contract was made void on the basis of unilateral mistake. So you have to make it very clear here that what clearly was the case was that the claimant knew that there was a mistake when it was formally written down in the contract, but they remained silent. They remained silent on that mistake because obviously that mistake would have incentivized them to get a lower deal and get a better deal and to maintain this better deal. So they thought, well, we won't say anything about the mistake that you've clearly made here because we want a better deal. It was concluded, therefore, that because there was a mistake as to the terms, and because the claimant knew about this mistake, but decided to say nothing, about it, because that meant that they would get a better deal, the contract was void on the basis of unilateral mistake. You can't really do that. It wouldn't be just or equitable for that to stand.